The conferees should stand up, please. On the count of 3, you're going to read out, you're going to take the oath on the oath form. 1, 2.
I, your name,
Agada John Elachi,
with the mention of your name, upon whom the rank of Senior Advocate of Nigeria
upon whom the rank of Senior Advocate of Nigeria
has been duly conferred, declare that I will at all times faithfully serve the interests of the Federal Republic of Nigeria in the capacity of Senior Advocate of Nigeria, and to that end will support and uphold the Constitution of the Federal Republic of Nigeria 1999 as amended, that I will to the best of my ability assist the courts of justice duly established in the Federal Republic of Nigeria in the performance of their judicial functions, and that I will at all times uphold the dignity of the rank of Senior Advocate of Nigeria. So help me God. Thank you.
Congratulations. Excuse me.
My lords, former Chief Justices of Nigeria, the Honorable Justice Mahmoud Muhammad, GCON, and the Honorable Justice Samuel Walter Onoran, GCON, my lords, the Honorable Justices of Supreme Court, serving and retired here present, President and Honorable Justices of the Court of Appeal, serving and retired here present, my lords, heads of courts and honorable judges of various jurisdictions here present, Your Excellencies, former governors of Sokoto State, distinguished Senator Tambuwal, CFR, the Deputy Governor of Jigawa State, Engineer Aminu Usman, former Ekiti State Governor, Dr. Fayemi, Honorable Attorney General of the Federation and Minister of Justice, Prince Lateef Fagbemi, SAN, distinguished members of the National Assembly here present, members of the inner and outer bars, the President of the Nigerian Bar Association, Your Royal Highness, the Emir of Lafia, Honorable Justice Sidi Bage, GSC, retired CFR, and other esteemed royal fathers here present, my Lord, Reverend Father Kuka, distinguished invited guests, gentlemen of the press, ladies and gentlemen. I am very excited to welcome you all to this special court session, organized to formally herald the 2023-2024 legal year of the Supreme Court of Nigeria, in line with our age-long tradition. Incidentally, this is the last legal year that I will be presiding over by virtue of the provisions of the 99th Constitution of the Federal Republic of Nigeria as amended. For the records, this 2023-2024 legal year of the court had commenced since Monday, the 18th day of September 2023. What we are doing today is, as usual, in compliance with our well-known tradition of assembling to give account of our performance in the outgone legal year, and as well confer the highly coveted rank of senior advocate on deserving senior members of the Nigerian Bar in both the advocates and academic categories. Similarly, speeches on the state of the justice sector of the country will be made by the Honorable Attorney General of the Federation and Minister of Justice, the Chairman of the Body of Senior Advocates of Nigeria, BOSAN, the President of the Nigerian Bar Association, and of course, the most senior of the newly inaugurated Senior Advocates of Nigeria. Meanwhile, it is quite disheartening to learn of the demise of one of the most iconic legal luminaries in Nigeria and the immediate past chairman of BOSAN, Professor Ben Nwabweze, SAN. May I crave your indulgence to join me in rising to observe a minute silence in his honor, please. May the precious soul of our departed professor rest in peace. Without mincing words, we at the Supreme Court have every reason to say that the 2022-2023 legal year was very eventful, though suffused with overwhelming uncertainty and grief of some sorts. It is ostensibly by the grace of the Almighty God that we are all alive to mark this new legal year in peace and good health. So many pleasant and unpleasant things had happened within the year under review, but we can joyfully say that we are still firmly on our feet and holding our grounds with the desired tenacity of strength. One of the most unfortunate and seriously disheartening events that eclipsed the Honorable Court is the course of the year that was that sudden demise of our brother, Honorable Justice Chima Santos Nweze, CFR GSC, on Saturday, the 29th day of July 2023, after a brief illness. His invaluable contributions to our jurisprudence can never go unmentioned and unnoticed in every sphere of our operations. As customary in the Supreme Court, this epochal occasion will be spiced with the swearing in of those senior members of the Nigerian Bar Association who have, in all ramifications and by all standards, excelled in the practice of law and are subsequently conferred with the rank of Senior Advocate of Nigeria. Expectedly, an occasion of this nature calls for great celebration. But even in the midst of that, it is still necessary that we spare a moment of our time to have a deep reflection and introspection on the journey we have made so far, with a view to knowing what direction to channel our energy and available resources. Though the journey through the rough tide can never at any time be convincingly adjudged to be smooth. However, the good thing is that it has always been favorably adventurous, as we have often been privileged to acquire new skills to aid us through the webs and tapestry of life, particularly our constitutional responsibility of adjudication. In those areas that we have excelled, we have to commend ourselves and as well endeavor to shore up the tempo of work, while in the areas of obvious shortcomings, as responsible and responsive mortals, we shall do a quick introspection and forge ahead with the right mindset and disposition to to achieve more favorable results in the course of the successive legal year. The Supreme Court, and by extension, the Nigerian judiciary, has fared well in the outgone legal year, even though our high level of resilience was brazenly taken to task by some overwhelming challenges. The prayers and admonitions and support of well-meaning Nigerians to a very large extent gave us the fortitude to remain steadfast and resolute in making a memorable impact on the Nigerian judicial landscape. As this new legal year unfolds, we would like to assure everyone that we are determined to redouble our efforts to bring about a judiciary that Nigerians, home and abroad, will be very proud and ecstatic about. As we celebrate the successes achieved in the past legal year, we also joyfully celebrate with our eminent legal practitioners who were thoroughly screened, examined, and found worthy in character and practice to be conferred with this very uncommon rank of Senior Advocate of Nigeria by the Legal Practitioners Privileges Committee, LPPC. The 2022-2023 legal year, which ended on Friday, the 21st day of July 2023, was robustly adventurous in all ramifications. Even though it presented some visible rough edges, the new legal year has yet offered us the privileged opportunity to diligently smoothen all the unwieldy terrain and fine-tune everything that may impede each free progress. I must say, with great pride and excitement, that during the outgone legal year, we'll experience so many positive, heartwarming developments in the Nigerian judiciary. In response to the yearning need for the injection of fresh blood into the nation's judicial service, we were able to appoint and subsequently swear in 23 new judges of the Federal High Court on Wednesday, the 4th day of October 2023. In the same vein, on Wednesday, the 20th day of September 2023, 9 justices of the Court of Appeal were inaugurated to strengthen the seamless dispensation of justice at the appellate level of adjudication in the country. What has been pending for a very long time, even long before I assumed office in June 2023, is the appointment of justices to fill the many vacancies that have been created as a result of deaths and retirements of our brother justices. For the first time in the history of the Supreme Court, 8 honorable justices were sworn in to fill the positions vacated by our esteemed colleagues who retired, as well as enlarging the profile of our judicial strength by increasing the number of justices to an all-time high number of 20 in November 2020. That, indeed, was first of its kind in our history. If for anything, that interesting development has, to a large extent, increased our adjudicatory capacity and reduced the number of nights we stayed awake as a result of workload. That in itself was a cherry news to the retinue of appellants that thronged the court on a regular basis. However, that joyful moment soon paled into lamentation and intense complaints of some sort from various quarters, as the trend experienced a sudden reversal owing to the unfanciful gale of retirement that soon hit the court, which has, for the very first time in a very long while, brought the number of our honorable justices to an all-time long of just 10 justices. Efforts were made by my predecessor to increase the number, but that was unsuccessful before he left office. However, the cherry news is that as soon as I assumed office on the 27th day of June 2022, I immediately got down to work on this urgent and immediate need in particular. Though we have not gotten them on board yet, I can convincingly assure the litigant public that within a very short while, the Supreme Court of Nigeria will, for the very first time in its history, get the constitutionally prescribed full complement of 21 justices. That is one of the legacies that I have been working assiduously to leave behind, as it now seems that the court has been somewhat jinxed from meeting its constitutional requirement since that piece of legislation was enacted several years ago. As we adapt the courts to stand ready for the future, we must not in any way whatsoever neglect the fundamentals that underpin the strength of our jurisdiction. Our courts should be trusted at home and abroad for the high level of respect for the rule of law and the constitutional and personal independence of our judiciary. That ought to serve as a major factor in the attraction of this country as a destination for investment and its reliability as an international partner in all spheres of human endeavor. We actually expected the independence of the judiciary to be given adequate statutory protection, not just at the federal level alone, but equally at the state level, so that they could be seen to be truly and genuinely independent in all ramifications. The rule of law, with all its well understood facets, has been highly questionable since the advent of democratic governance in 1999. It is noteworthy that reputation can take a long time to establish, but can be dissolved and completely destroyed in an instant, sometimes inadvertently though. The rule of law and the holistic independence of the judiciary should always be cherished by all. As the Chief Justice of Nigeria, I will do everything within my ability to make it remain part of my responsibility to nourish. The judiciary as it is today is more deserving of public trust and confidence than ever before, and we are poised to reposition it for effective justice delivery to make our beloved country a destination of note in the observance of the rule of law and tenets of the constitutionalism. Nigeria must move forward in all spheres of life, and we must collectively evolve a society where things must be done right to get the right environment for every right thing to thrive rightly for our collective good. The countries which we today find leading the Committee of Nations had long ago shattered the shackles that kept them halted and prevented innovation. There is no gainsaying the fact that research and development are the tools that keep us moving with the pace of the world. If we do not grab on to these essential ingredients of development, we will perpetually lag behind the world. It is yet an unsatiable fact that those who remain intransigent to change and improvement never achieve anything meaningful. I've always remained an ardent believer in continuous improvement. As iron had to bear the rigors of fire and hammer before turning into steel, humans need to step outside of their comfort zone to chisel away the dust of lethargy that they gather with time from their persons. The Nigerian judiciary, over the years, has strove assiduously to carve a reputation for great integrity and independence, which will ultimately embolden us to act without fear of intimidation or harassment from the other arms of government. We, the members of the judicial hierarchy, have undoubtedly inherited a legacy of dedicated collective endeavor by the bench and the bar by painstakingly establishing an unbroken tradition of high efficiency, perfect integrity, and fearless independence. Let me state it clearly here that the true touchstone for measuring the success of a judicial institution is the degree of confidence reposed in it by the public. It is a solemn pledge that we, as judicial body, are making at this occasion, that we are definitely going to work more assiduously and tirelessly to make our country earn for itself the fullest respect and confidence of both the citizens and the international community. Is a germane at this juncture to restate the obvious fact that judiciary has a special role to play in the task of achieving socio-economic goals enshrined in the Constitution. While maintaining their aloofness and independence, The judges also have to be fully aware of the social changes in the task of achieving socio-economic justice for the people of our dear country against all odds. I therefore advise all judicial officers serving in our jurisdiction to make books their armor and hard work their armaments to confront the headwinds of ignorance, conservatism, and stagnation. It is imperative to know that the world we are only remembers those who lead from the front and set trends for others to emulate. So, you should never be afraid of setting sails through uncharted territories, provided your knowledge is adequate and your skills are equally well tested. I wish to restate unequivocally that integrity is an essential quality of a judicial officer, and he must, as a matter of necessity, exhibit the standards of integrity, morality, and good behavior which he sets for others. In a situation where a judge decides a case wrongly out of motives, he shakes the faith of the litigant public and by extension the whole society. Such a judge who does not maintain highest standard of integrity has no right to continue to occupy the chair as a judicial officer. In the same vein, if a judicial officer is found to be corrupt, then he cannot be allowed to hold such a defined chair of a judge. It was Socrates, the great Greek philosopher, who stated in clear terms the 4 things that improve a great judge. These are to hear courteously, to answer wisely, to consider soberly, and to decide impartially. It has been rightly asserted that judicial officers, by the nature of their calling, discharge defined functions even though they themselves, as mere mortals, are not defined. I'm very much convinced that judicial officers at the various hierarchy of courts in Nigeria are discharging their judicial functions in a befitting manner. But as the Chief Justice of Nigeria, I still strongly desire from all judicial officers across courts to lead a disciplined and principled lifestyle that will enhance their trust and integrity. Quietly, judges owe the society a great duty of always deciding cases without fear of favor, affection, or ill will, friend or foe. For the open time, I wish to honestly assure all judicial officers that if you are discharging your functions as an upright judicial officer by genuinely following the norms, then you have no cause to be afraid or feel intimidated by the often frivolous complaints or vitriolic attacks made by persons having vested interest. However, I expect every judicial officer to work very hard and also be very honest and courteous to the litigants, witnesses, and members of the bar, and discharge all your judicial functions with all the humility at your command. Even while doing this, it is still necessary to have at the back of your minds that public opinions, sentiments, or emotions can never take the place of the law in deciding the cases that come before you. The law remains the law, no matter whose interest is involved. In all we do, as interpreters of the law, we should endeavor to sever the strings of emotion from logic and assumption from fact. We should never be overwhelmed by the actions or loud voices of the mob or crowd and now begin to confuse law with sentiment or something else in deciding our cases. Nevertheless, unnecessary and unwarranted utterances are bound to embarrass not only others but the judge himself. Thus, what should be asked, and what should not be asked should be avoided. I admonish our judges to, as usual, receive what is tendered in court and eschew what is against the law and facts after thorough analysis and assimilation, both in and out of court, which exercise is, of course, part of judgeship. The sister's wife must be above board. Your image and reputation, both inside and outside the court, must be pristine and crystal clear to all and sundry. Like I said earlier, be bold in all your judgments by deciding cases without fear or favor, because fear and favor come in many hues and colors. For instance, fear of one's own past, of peer pressure, of public criticism, etc. Like some people often misconstrue, favor does not only come in monetary terms, but also through nepotism, personal bias, and prejudices. We should all know that if the faith of the people is to be maintained in the judiciary, then the river of judicial process has to be kept pure. On that basis, we must ensure fair and favor at all costs. If the people think your judgment is biased, is tainted, is partial, they will doubt the judicial process and the river of justice will stand contaminated. No doubt about that. Therefore, it is our solemn responsibility to keep the river clean at all times. Nevertheless, to say that impartiality is the hallmark of a judge. So, I admonish all of us to always be impartial in all our judgments. I'm saying all this now because I will never have this great privilege and opportunity to address the galaxies of legal luminaries, judicial icons, and distinguished personalities in the justice sector of our dear nation in another legal year of the Supreme Court as Chief Justice of Nigeria in my entire lifetime again. The Corruption and Financial Crime Cases Trial Monitoring Committee, COTRIMCO, was inaugurated in 2018 by the former Chief Justice of Nigeria, the Honorable Justice W.S.A. Onoy, GCON, with the sole aim of fast-tracking the trial of corruption and financial-related crimes in the country. The committee, which is headed by amiable retired Justice of the Supreme Court, Honorable Justice Sulaiman Galadima, CFR, has been working assiduously with various heads of courts to ensure that there is a remarkable rise in the dispensation of corruption and financial crime cases in the country. With the impressive effort they put in during the last legal year, some commendable results were achieved in the disposal of cases. This achievement was brought about as a result of increased and continued vigilance of the committee. The two leading anti-graft agencies in the country have also been trying to amplify the war against corruption. The ICPC was able to successfully secure a total number of 10 convictions, while the sister agency, the EFCC, was able to secure 1,094 convictions within the same period under review. The matters filed at the Supreme Court from the 12th day of September 2022 to the 11th day of July 2023 are 1,271, comprising of motions and appeals. Out of this, we had 388 political appeals, 215 criminal appeals, and 464 civil appeals. Similarly, the court considered a total number of 49 criminal motions, 153 civil motions, and 2 political motions. Between the 30th September 2022 and the 11th day of July 2023, the Supreme Court delivered a total number of 251 judgments. Out of these, 125 were political appeals, 81 were civil appeals, and 45 were criminal appeals. Within the period under review, precisely 10 months duration, a total number of 91 rulings were delivered by the Honorable Court. To a very large extent, I will confidently say that this scorecard is impressive, fascinating, and appreciable in view of the unpleasant events that dotted the legal year, especially the attenuating number of justices of the Supreme Court bench, which has to do with some challenges that could not easily be surmounted by one arm of government alone. I attribute the tremendous successes recorded in the course of the last legal year by the Honorable Court to the doggedness exhibited by my industrious and team-spirited brother justices and the general staff. Even as we celebrate the successes recorded in the past legal year in the disposal of cases, I would like to admonish all Nigerians on the imperative of being less litigious and be more disposed to alternative dispute resolutions to free the courts of this unnecessary overstretching of both human and material resources. I've made it clear at different occasions that it is not every dispute that must find its way to the court, and it is not every matter that must, of course, come up to the Supreme Court on appeal. Our laws have to be amended to make most appeals to end at the Court of Appeal, which is competent, dexterous, and well-equipped with the right materials and manpower to adjudicate effectively and resourcefully. In every dispute, only one party must win, and winning could come after intense legal fireworks that is transparent and based solely on subsisting laws of the land. We cannot import foreign laws to try our cases here, as some litigants would erroneously and desperately want us to do in the case to get victory. If we really want to make progress as a nation and collectively build a virile legal framework that will serve our interests to the best of its ability, we must begin to have a change of attitude. We are not only here to celebrate the new legal year, but to equally speak truth to ourselves and also purge ourselves of most of our wrongdoing and misadventures. The agglomeration of all these problems and mindset has largely accounted for the several appeals that are currently pending in the Supreme Court and the Court of Appeal too. The good news I would like to share here again is that the Alternative Dispute Resolution Mediation Center of the Supreme Court has been fully furnished and equipped with both materials and personnel to function effectively and efficiently. Very soon, I will inaugurate the center for full operation. So, we should begin to take advantage of alternative dispute resolution mechanisms to resolve some of our disputes with a view to cutting down the cost of litigation and also free the courts from case overload. On the 15th day of February 2023, I issued the Supreme Court Pre-Election and Election Appeals Practice Direction 2023. That came on the heels of the inauguration and training of hundreds of election petition tribunal members that were built to adjudicate on all petitions emanating from the 2023 general election and the succeeding off-cycle elections in the country. All the tribunals across the country have endeavored to work assiduously to deliver judgments within the time permitted by the Electoral Act and allied subsisting legislations. I commend them for conducting themselves within the ambit of the law. However, I expect members of the public who have any complaints bordering on any form of untoward behavior or misapplication of the law by any member of the tribunal to challenge such to the National Judicial Council for prompt action, as I will not condone any form of malfeasance or nonchalance from any judicial officer in the tribunal or regular court. My lords, distinguished invited guests, ladies and gentlemen, as we all know, the rank of senior advocate of Nigeria comes with so much prestige and greater responsibilities too. Those conferred with the rank automatically become members of the inner bar and apostle of the temple of justice. It is an honor to conferee. It is an honor no conferee can afford to take for granted. The Legal Practitioners Privilege Committee had painstakingly screened and diligently assessed all the documents submitted by the applicant before arriving at his decision. Even though there is no human system that could be adjudged to be infallible, however, with the effort and commitment invested in the exercise by the committee, I can say confidently and assuredly that they have done remarkably well. I sincerely appreciate your dedication, commitment, and sacrifice throughout the duration of the screening, inspection, interview, and final announcement exercises. The guidelines for the conferment of the rank of Senior Advocate of Nigeria and all matters pertaining to the rank 2022 require a very high standard of merit from all the applicants vying for the award. Every requirement contained in the guidelines was observed before arriving at the final list. The number of applicants for 2023 Senior Advocate of Nigeria Award was 114. Out of this number, 101 are advocates and 13 are academics. The total number qualified applicants shortlisted after the advocates' first and second filtration stages, academic pre-qualification, academic second filtration exercise, the independent appeals hearing and chambers inspection exercise, etc., was 69 in number, comprising 57 advocates and 12 academics. After conducting the specified screening and filtration exercise, which include a number of appearances in superior courts, recommendations by Honorable Justice of the Supreme Court and Honorable Judges of Superior Courts, chamber inspection, approval on eligibility and integrity of the candidates from the Nigerian Bar Association, Body of Senior Advocates of Nigeria, and of course, the general public, among others. The LPPC came up with 58 successful candidates who, by all standards, can be regarded as eminently deserving of the rank of Senior Advocates of Nigeria. Out of this number, 57 are advocates, while only one is an academic. This is indeed heartwarming and exciting, particularly for those who have accomplished this remarkable feat. On behalf of my learned brother justices of the Supreme Court and members of the Legal Practitioners Privileges Committee, I sincerely congratulate these 58 successful senior advocates that have just been sworn in. Congratulations. No success comes easy in life because a lot of sacrifices and hard work are often invested. You have labored so hard for it. You deserve every privilege, honor, and pride that comes with the rank. The LPPC deserves enough commendation for endorsing the elevation of these eminent 58 legal practitioners who have, from all indication, showcased unassailable professionalism and excellence in legal practice. As senior advocates of Nigeria, you now carry a heavy burden on your shoulders. From the moment you leave this courtroom today, everything in you and about you will now be freely scrutinized and dissected by everyone that comes in contact with you. There's nothing like private life for you henceforth, as whatever you either told regarded as private life will now be treated as public life by members of the public. And there's nothing you can do about this. So, watch your utterances, watch your actions, and watch the kind of company you keep, because you have already assumed the role of ministers of the court, as you are now expected to assist the court to attain justice, equity, and fairness in all ramifications. You must display enormous integrity, self-discipline, and high standard of advocacy as custodian of justice. The privileges you are conferred with today does not in any way make you superhuman, however, because humility and self-control still remain the essential tools to engage in wrestling the fables of life. Unfortunately, however, after attaining this rank, some senior advocates will instantly become mere casual visitors to the courtrooms, as they now see themselves to be too big to appear in court. I'm using this very important occasion to tell you all that this is the most auspicious time to make your presence regular and significant in the court. Before I end this speech, I would like to express my warm gratitude and appreciation to everyone that has decided to be physically present here today to witness this very important program, heralding the 2023-2024 legal year service. We are very grateful to you all for according us this great honor, even at the expense of your very demanding schedules. I also wish to express my appreciation to the Honorable Minister of Justice and Attorney General of the Federation, Prince Lateef Fagbemi, the Chairman of the Body of Senior Advocates of Nigeria, the President of Nigerian Bar Association, Honorable Yakub Makiao, SAN, and of course, the spokesperson for the newly conferred Senior Advocates of Nigeria, Mr. Felix Ota Ofia, SAN, for graciously accepting our invitation to address this very important gathering. Thank you very much for spending your precious time with us. I wish you all journey masses back to your respective destinations. Congratulations once again, Ilana Senior Advocate. Next, on the agenda of the program today is the address by the Honorable Attorney General and Minister of Justice, Prince Lateef Olasunkanmi Fagbemi, SAN. Learned Attorney General.
My Lord, the Honorable the Chief Justice of Nigeria, my Lord the Honorable Justice Oluka Odiaruola, GCON, my Lords, former Justices of Nigeria here present, my Lord, Honorable Justices of Supreme Court serving and retired, my Lord, the President of Court of Appeal, Honorable Justice Monica B. Mensah, CFR, my Lords, Honorable Justices of Court of Appeal, serving and retired, my Lords, my Lord, the Chief Judge of the Federal High Court, my Lord, the Chief Judge of High Court of Federal Capital Territory, my Lord, the President of National Industrial Court, all heads of court here present, my Lords, judges of various jurisdictions here present, serving and retired, the Chairman of Body of Senior Advocates of Nigeria, the President, Nigerian Bar Association, learned Senior Advocates of Nigeria here present, the just sworn-in Senior Advocates of Nigeria and their families, distinguished members of the Altar Bar, Your Excellencies of various states here present, the principal officers and members of National Assembly here present, honorable ministers, traditional rulers here present, the Chief Registrar, members of the Legal Practitioners Privileges Committee, members of the Fourth Estate of the Realm, other invited guests, distinguished ladies and gentlemen. My Lord, the tradition is that I should stay until the end of this exercise. And I should have mentioned this to my Lord, the Honorable the Chief Justice, but I apologize. I'll crave your indulgence to allow me go after this exercise because there is a FEC meeting, but I feel duty bound to be here first. My noble lords, it is my utmost pleasure to attend the solemn ceremony marking the commencement of a new legal year of the Supreme Court and formal conferment of the coveted rank of Senior Advocate of Nigeria, SAN, on eminent colleagues who have been found suitable and worthy in character and practice of the law, having scaled the tedious selection process and requirements of the Legal Practitioners Privileges Committee. Today's ceremony, encapsulating two worthy events in our most noble profession, is of particular significance to me. It is the first of its kind I will be attending in my current capacity as Attorney General of the Federation and Minister of Justice some 96 days ago. I wish to commend their noble lords for the Honorable Justices of the Supreme Court of Nigeria for their dedication and hard work in the outgone legal year amidst some inherent challenges. In April 2023, my Lord the Honorable the Chief Justice of Nigeria disclosed that the Supreme Court had delivered 272 judgments midway into 2022-2023 legal year in civil, criminal, and election-related appeals under immense pressure. The number of judgments, no doubt, must have increased by the time the court proceeded on vacation in July 2023. This is a testament to their Lordship's due diligence, industry, and endurance. I recall that during the 2022-2023 legal year ceremony in November 2022, my Lord the Honorable the Chief Justice of Nigeria disclosed that the pending backlog civil appeals stood at 4,741 criminal appeals, 1,392, while moribund appeals constituted 751 in number, thereby bringing the total number of pending appeals before the Apex Court at that time to 6,884. These worrisome statistics must have increased into 2023-2024 legal year. I also wish to pay tribute to the memories of the retired or departed justices of the Supreme Court who were part of the success in the outgone legal year. The foregoing is no doubt a very concerning situation that must be holistically addressed if we are to get the best of our Supreme Court and indeed their lordships. We must begin to develop innovative solutions towards enhancing the working capacity of the Supreme Court, cutting down on the number of appeals that gets to this honorable court, implementing critical judicial reforms, as well as adopting alternative dispute resolution mechanisms. I am aware that the process of filling the vacancies for the justices of Supreme Court has begun. I would, however, like to use this opportunity to urge the leadership of the National Judicial Council to fast-track the process of achieving a full complement of the Supreme Court and to also concurrently put in place the process of filling the consequential vacancies that will be occasioned at the Court of Appeal to avoid undue delay and minimize disruptions at that level. The administration of President Bola Ahmed Tinubu, GCFR, has severally expressed readiness to implement judicial reforms with the cooperation of the judiciary. We therefore earnestly await the judiciary to set the ball rolling to enable the other arms play their part in this critical aspect of nation building. Let me now progress to the second reason for our gathering here today, which is to felicitate with 58 of our illustrious colleagues who have just been adorned with the revered regalia of learned silk. It is indeed with high sense of nostalgia and elation that I congratulate you all on this worthy professional attainment. The conferment of the rank of Senior Advocate of Nigeria is not just a recognition of excellence for those conferred, but it is also a motivation for those aspiring to be admitted to the inner bar. I also wish to commend the Legal Practitioners Privileges Committee, otherwise known as LPPC, and all stakeholders who have participated or contributed their quota to the emergence of the new silks for the yeoman's job you are doing over the years to reward excellence, ethics, perseverance, and as well as sustaining standards in the legal profession. I join the Legal Practitioners Privileges Committee, the Nigerian Bar Association, and the Body of Senior Advocates of Nigeria not to relent in maintaining and enforcing a continuous culture of excellence, legal ethics, scholarship, and professionalism in the practice of law in Nigeria. I must state emphatically that the process that led to the conferment of the rank of the rank on those who have just been conferred today is one of the most credible processes I have ever participated in since I had the privilege of becoming a member of LPPC some years back. To the new silks, I warmly welcome you to the inner bar. It is indeed a remarkable privilege to be chosen and decorated with honor amongst other colleagues. As the name of the LPPC implies, the conferment of the rank of Senior Advocate of Nigeria is a privileged position for the deserving only. Every visionary professional strives to attain the apex of such profession. Expectedly, the rank is being conferred on worthy advocates as a prestigious honor in recognition of their excellence in advocacy and leadership role in the field of law or legal practice. Your new and enviable status demands that you must be honest and maintain professional standard at all times within and outside the courtroom towards the judex, colleagues, clients, and the public in general. You must maintain very high standard of professional conduct in the discharge of your duties. Being a privilege also means that it can be lost or taken away. It is worthy of note that under the new rules, a name is struck off here. I wish to remind you that your new status comes with peculiar privileges, benefits, challenges, and responsibilities. Your preoccupation should not be limited to the privileges and pecuniary benefits associated with the rank. You are required to advance the cause of justice, rule of law, promote the image and rating of the judiciary and the legal profession as worthy ambassadors. You should always be willing and ready to exhibit exceptional understanding and knowledge of the law, contribute to legal education. The development of legal profession rests on your shoulders. You must, therefore, advocate for technological and modern innovations that will bring the practice of law in Nigeria in line with global standards. No restoration of rank after withdrawal. Gentlemen, as you have been welcomed to the inner bar, it is important to remind you that you are the first set of senior advocates of Nigeria to be elevated under the provisions of 2022 guidelines for the conferment of the rank of senior advocates of Nigeria and all matters pertaining to the rank. I am sure you have read some of the highlights of the new guidelines, in particular, paragraph 26, subparagraph 4 of the new guidelines. Whether or not you have read the paragraph, let me seize this opportunity to bring it out. One of the highlights of the new guidelines is that, unlike the 2018 guidelines, which contained provisions for discipline of earnings holders of the rank for the restoration of the rank after 3 years of withdrawal upon fulfillment of certain conditions, the 2022 guidelines as at today makes no provision for restoration of the rank after withdrawal. In other words, once the Legal Professionals Privileges Committee, pursuant to the provisions of paragraph 26, subparagraph 4 of the guidelines, withdraws the rank from any holder who may have breached the provisions in subparagraph A to E to H, the withdrawal is final and the rank cannot be restored afterwards. It therefore behoves on any senior advocate of Nigeria to strive to conduct himself in utmost professional standards and to avoid running foul of the rules of professional misconduct of the legal practitioners. Participation in media trial. One of the areas you must avoid, like the plague, is the unwholesome practice of engaging in media trial of cases pending before the courts. It is unprofessional for a legal practitioner, nay, senior advocate of Nigeria, to be seen engaging in analysis of cases pending before the court. It is fast becoming the norm, and sadly so, for legal practitioners to appear at television or radio stations discussing pending matters. We have also seen lawyers after court sitting discussing on what transpired in the proceedings. You must resist the urge to engage in such practice. You must also reject the temptation by the media houses, inviting you to analyze and discuss pending matters. The doctrine of sub judice enjoins lawyers and even members of the public to refrain from commenting and discussing live cases. You should not be seen breaching this doctrine. However, where judgment has been delivered in a given matter, lawyers and the public are free to analyze and discuss the decisions without impugning the integrity of the judicial personnel involved or attacking the professional competence of counsel involved in such matters. As leaders in the bar, you should resist the urge to engage in such unbecoming conduct. It is therefore your abiding duty to promote the integrity and independence of the judiciary at all times. Every worthy professional in the world seeks the good and progress of their profession. We, the members of the legal profession, cannot afford to ignore our nobility by publicly denigrating or ridiculing the judiciary and, by extension, the profession by action and utterances. We can only do so to our own peril. I am not advocating that we should condone or tolerate shortcomings or any form of misconduct, but we must follow accepted procedure and channels to avoid collateral and collective damages. Your coming on board at such a challenging time as this requires that you passionately seek to enhance or achieve a paradigm shift from the status quo by avoiding infamous conduct that will further damage public perception about our court system, being mindful of the fact that the importance of public confidence in the judiciary cannot be overemphasized. Then I talk of mentorship. Having been elevated to the inner bar, you are now regarded as part of the leadership in the profession. However, you are still amenable to mentorship of the very senior members of the inner bar. Law is a dynamic profession. We learn every day, and the seniors are there to play the role of mentors. You are therefore in a unique position of still being mentored by the elders in the inner bar, while at the same time acting as mentors to the younger ones at the bar. You must therefore be good mentors by showing good examples in and outside the court room. I believe that the one-day induction course organized by the Bosan in Lagos last week will go a long way in assisting to appreciate the tasks ahead and how to go about them. As legal practitioners, we act as the conscience and gatekeepers of the legal profession. Legal practitioners must refrain from abusing their privileged position as the link between the litigant and the judiciary. It is not the exclusive prerogative of litigants to determine which cases get filed in court or which judgment goes on appeal. We must be firm in sieving these cases in order to avoid filing frivolous cases or appeals which clog the already congested court dockets. In this wise, I wish to commend to you the wise admonition of His Lordship, Daunsi Olugbemi Koka of blessed memory, in the case of Adeomi and Plastek, citation supplied, where he held, quote, every lawyer, upon his own responsibility, must decide what cases he will bring into the court for plaintiffs and what cases he will contest in court for the defendants. It is the responsibility for advising as to questionable transactions, for bringing questionable suits, and for arguing questionable defenses. He cannot escape it by arguing as an excuse that he is only following his client's instruction, unquote. On this note, please accept my congratulations on your ascendancy to the zenith of your professional career as advocates, and these attainments should not be a mere badge or right for bragging and show off. You must remain true to the calling of being advocates in the temple of justice, which was what earned you the conferment of this prestigious rank. In closing, my Lord, the Honorable Chief Justice, Your Excellencies, distinguished ladies and gentlemen, I wish to utilize this opportunity in wishing your lordships good health in body, spirit, and soul, required for a most successful legal year, full of remarkable milestones. I also wish our new learned souls God's guidance and best wishes in your future endeavors as senior advocates of Nigeria. I thank you all for the audience and the attention. Thank you.
Thank you very much, Honorable Attorney General. Now, to the most senior of the Senior Advocate of Nigeria, Professor A.B. Kasumu, SAN, or his representative as the most senior advocate here present.
May I start by apologizing on behalf of Professor Dele Kasumu, SAN, the leader of BOSAN, for his unavoidable absence. I, Ebunsho Funde, was mandated by him to speak on behalf of the body of senior advocates. The Chief Justice of Nigeria, the Honorable Justice Olukayode Ariwola, GCON, other justices of the Supreme Court of Nigeria, the Honorable President of the Court of Appeal, Honorable Justice Monica Dongba Mensen, other justices of the Court of Appeal, the Honorable Attorney General of the Federation and Minister of Justice, Prince Lateef Fagbemi, SAN, the Chief Judge of the Federal High Court and Chief Judges of the Federal and State High Courts, the President of the Nigerian Bar Association, Mr. Yakubu Maikao, SAN, eminent senior advocates of Nigeria, members of the bar, ladies and gentlemen, and other guests. I feel honored to be given the opportunity to deliver this speech on behalf of the body of senior advocates of Nigeria, BOSAN, on this occasion of the marking of the commencement of the 2023 Supreme Court legal year and the conferment of the prestigious rank of Senior Advocates of Nigeria, SAN, on the 58 conferees today. Accordingly, on behalf of BOSAN, I congratulate the Chief Justice of the Federation and other eminent justices of this court on yet another legal year. May God Almighty strengthen you with profound wisdom, pristine health, and His grace in the discharge of your constitutional duties. In the same vein, I welcome every member of the bar to the 2023 legal year. I also congratulate you, today's 58 conferees, for your worthy achievements. I am aware that you had on Wednesday, the 22nd day of November 2023, undergone a pre-conferment program organized by BOSAN in Lagos. Accordingly, I will not reiterate the duties and responsibilities expected of you in your new status. You have become leaders of the bar, and you must ensure that the truest tenets and best traditions of the bar, of the profession, are upheld. I therefore welcome you to BOSAN. I believe it is only fitting and proper to pay a tribute to the late Professor Ben Nwabweze, SAN, and ETC, who was the leader of BOSAN up until his passing to eternity last month, to eternal glory last month. He was no doubt a legal icon and an accomplished legal scholar and advocate who combined industry with great commitment to his professional responsibilities. It is noted with admiration the fact that he lived an exemplary life and, by dint of hard work and exceptional professional exertions, rightfully earned for himself an elevation to the inner bar amongst the second set of lawyers of distinction to be conferred with the prestigious rank of Senior Advocate of Nigeria by the Legal Practitioners Privileges Committee in 1978. This was in recognition of his great contribution to the development of Nigeria's legal jurisprudence, especially in constitutional law, constitution drafting, and legal practice in Nigeria. May his noble soul rest in peace. Given the fact that this gathering has brought together very senior members of the bench and bar, it is a good time to take stock and reassess the justice delivery system and the bar, with particular emphasis on BOSAN and its members, in a bid to identify the perceived areas of weaknesses in the system, as it is often said that the first step to solving a problem is recognizing that the problem exists. To that end, permit me to briefly touch on some of the issues considered to bedevil our system and suggestions of some antidotes. I start with the body of senior advocates. It is ironic that the guidelines for the conferment of the rank of Senior Advocate of Nigeria 2022 requires all applicants to submit a minimum of 4 final judgments of the Supreme Court in which they were lead counsel and which must have been delivered in the last 10 years to be eligible for consideration for the rank. This singular requirement puts undue pressure on the Supreme Court because the applicants for the rank resort to filing and maintaining unnecessary appeals at the Supreme Court in order to achieve this threshold. Perhaps the guidelines should be reviewed to require a much smaller number of appearances in all the Supreme Courts. Perhaps more emphasis should be placed on the nature and complexities of each case argued rather than the number. Emphasis should be placed on quality rather than quantity. I was in the chambers of the highly revered Chief Frederick Rotimi Alade Williams when BOSAN was formed about 40 years ago. It was to be the leadership arm of the Nigerian Bar Association, where the ethics and the finest traditions of the bar were to be preserved and encouraged. The body never had a constitution, and it was to be free of all government and other external influences, which was why it was not a government institution. It is a private organization to promote professional responsibility, integrity, and the highest standards of professional ethics, etiquette, and discipline amongst its members. All these were to be done to ensure the independence of the judiciary, the rule of law, and to promote the highest standards of professional practice in Nigeria. It was expected that all these virtues would be achieved since its members were meant to be the crème de la crème of the profession. The leader of the body, in the absence of the Attorney General of the Federation, where he was a son, was Chief Rotimi Williams, he being one of the first 2 to be conferred with the rank when it was established in 1975. He was also the most senior. He chaired most meetings in the absence of the Attorney General. Where the Attorney General was not present, or where he was present but had a specific role to play in his official capacity at an event, then Chief Rotimi Williams, or in his absence, the Senior Advocate of Nigeria, next in rank after him there present, would deliver the address or preside at the meeting or event. It is therefore an aberration that these days some senior advocates of Nigeria, who are not necessarily the most senior present, deliver or present addresses or speeches at ceremonies on behalf of BOSAN. That was not the intention of those who established the body. Maintaining seniority was sacrosanct in terms of preserving the honor and privilege of the rank of senior advocate of Nigeria, and should remain sacrosanct till date. With the passing of Professor Benoit Bose last month, the leader of the body is Professor Alfred Bamidele Kasumu, he being the most senior living senior advocate of Nigeria. As stated above, the body did not have a constitution. The administrative setup was such that, apart from the chairman and the leader, members were appointed into offices, and they willingly agreed to serve. This was aimed at removing politicking and rancor amongst our ranks, and it worked well for very many years. Nomination to offices were received with popular acclamation, and seniority was always a determining factor as to who was appointed into an office. A senior member who was willing to serve would normally be given precedence. The first secretary of the body of senior advocates of Nigeria was Chief Shola Rhodes, and the first treasurer was Mr. Kehinde Shofola. When they both got tired of serving, Chief Rotimi Williams nominated Mr. Sheisho Emimo as secretary and Mr. Kola Awodeyin as his assistant, and Mr. Kehinde Shofola nominated Professor S.A. Adesoya as his successor as treasurer. Members readily agreed to the nominations, and those appointed served creditably, with the body being recognized as a strong voice in the legal structure of Nigeria, but by adhering to and upholding its aims and objectives. In 2007, a constitution was drafted for the purpose of giving a proper structure to the body. After several years, the constitution was ratified by the body, and the body of senior advocates of Nigeria was registered as an incorporated trustee in 2011. The constitution provided for the Attorney General of the Federation as chairman, provided he is a senior advocate of Nigeria, and the most senior living senior advocate of Nigeria as vice chairman. Other officers are financial secretary, the assistant secretary, the treasurer, the financial secretary, and the program and publicity secretary. I should not fail to mention a disturbing recent trend to divide the body and create branches. The constitution of the body does not provide for branches or chapters or groups. The likely fallout of such a division would be the inability to speak with one voice and the lack of credibility which the body will be subjected to due to the cacophony of voices. We should never let this happen. We therefore trust that the Chief Justice of Nigeria and the heads of other superior courts in Nigeria will be wary of lending weight to the activities of any splinter group. In having its full complement of 22 justices in the Supreme Court, it is my view that senior advocates should be appointed. The same should apply to appointments to the Court of Appeal. A lot of lip service has been paid to this in the past. This gesture should also be extended to the academia. The reason for this is that the more varied the backgrounds of the persons in the pool from which appointments are made, the more the court will benefit from the varied experiences that will be shared. Indeed, in the past, we have had practitioners from the academia and from the bar who were appointed to the Supreme Court and who served creditably. Examples are the Honorable Justice Taslim Olawale Elias and the Honorable Justice Augustine Nnamani. There are some issues bedeviling the administration of justice in this country, and I would like to highlight a few of them and proffer solutions. I start with inordinate delays. The most obvious manifestation is the inordinate amount of time it takes to dispose of cases. On 2nd February 2005, the Attorney General of Lagos State filed an originating summons at the High Court of Lagos State against National Sports Lottery, NSL. NSL filed a preliminary objection challenging the jurisdiction of the court. The court dismissed the preliminary objection on 18th April 2005 and NSL appealed. In a judgment delivered on the 16th of July 2008, the Court of Appeal agreed with NSL that the High Court of Lagos State lacked the jurisdiction to entertain the suit. The Attorney General of Lagos State instituted an appeal to the Supreme Court in 2009. The Supreme Court on 31st March 2023, 18 years after the matter was commenced at the High Court, held that the High Court of Lagos State indeed had jurisdiction and then sent the case back to the High Court of Lagos State for a determination on the merits. If it took 18 years of ordinary litigants, Shell Petroleum Development Company Limited versus Amaro and others is a case commenced in 1983 by, as I understand it, the father of one of the new silks we are celebrating today in the High Court of Bendel State, Warri Judicial Division. I understand that the new silk was only 2 years old at the time of the commencement of this case. The suit was consolidated with another suit in 1985, and the High Court delivered its judgment in favor of the plaintiffs in 1997. The defendant appealed in the same year, and the Court of Appeal dismissed the appeal in 2000. Dissatisfied once again, the defendant appealed to the Supreme Court. The Supreme Court delivered its judgment dismissing the appeal in 2015, 32 years after the suits were commenced at the High Court. By this time, the new silk had, as I again understand, qualified as a lawyer and even appeared with his father at the hearing of the appeal at the Supreme Court. Things ought not to continue like this, and we, the bar and the bench, need to come together to take concrete action to ensure that a system of administration of justice is fit for purpose. If we do not do this quickly, the confidence of the public in the system, which is at an all-time low, will plunge to a point where it may no longer be redeemable. It is no coincidence that citizens now prefer to take their civil disputes to law enforcement agencies for resolution. Law enforcement agencies now fill the void that has been created by our failure to make the system of administration of justice work for those who should see the courts as the last hope of the common man. Indeed, I have a friend who told me that if he wanted to evict his tenant, he would forcibly evict him and take possession of the house and then defend any action brought against him. Another point I wish to highlight is inconsistent judgments. There are too many inconsistent judgments emanating from our appellate courts. This makes it difficult for a litigant to be able to take an informed decision as to whether to maintain or defend an action. It has also made it difficult for the lower courts to observe the rule or principle of stare decisis effectively. The judgments that come out of the courts of its jurisdiction are a mirror through which outsiders view the quality and state of its system of administration of justice. The more overwhelmed our justices are by their caseload, the less time they will have to write well-thought-out judgments. For me, as one who has been in active legal practice since 1972 and been in the inner bar since 1988, this is one of the most devastating effects of our system of administration of justice today. Interference with the administration of justice by administrative acts of the court. A lot of delays are caused by disruptive administrative acts of court administrators. This is most evident in the way judges are transferred. It is an established principle of our law that when a new judge takes over a part-hard matter, trial must start de novo. Why then do our federal courts of first instance transfer their judges to different states or divisions without adequate planning? Ideally, if judges must be transferred, they should know at least 1 year in advance, and they ought not to be assigned new cases during that transition period. The same goes for retiring judges. One of the most predictable things in our judicial system is the date on which a judge will retire from service. Why then don't we proactively manage the dockets of judges whose retirements are imminent so that the trials before them do not have to be started de novo after they retire? These are problems that could easily be dealt with administratively by court administrators. Delays caused by redundant provisions in the rules of court. We need to take another look at the rules of our appellate courts that states that once an appeal has been entered, the appellate court shall be seized of the whole proceedings. This rule has become a tool with which lawyers delay proceedings, safe in the knowledge that the lower courts are reluctant to be seen as engaging in, quote, judicial rascality, unquote, by continuing to hear cases that are subject of an interlocutory appeal, which they have the discretion to do in appropriate cases. While this problem has been somewhat solved in criminal cases by Section 306 of the Administration of Criminal Justice Act, there is a need to amend the rules of our appellate courts to make it harder for lawyers to tie the hands of lower courts by simply rushing to have their interlocutory appeals entered, no matter how bereft they are of merit. In effect, it is my suggestion that rules of the various courts be amended to remove provisions that are impractical or work injustice of some sort. Preference for technicality over substantial justice. Judges are human after all, so when they are overwhelmed by their caseload, it is inevitable that they will treat cases in a perfunctory manner. The goal will become disposal of as many cases as possible, even if that means sacrificing justice. It is therefore not surprising that the great number of judgments coming out of our apex court, which should be a court of policy, are disposed of on technicalities. The days when our Supreme Court admonished that, quote, justice is not a fencing game in which parties engage themselves in an exercise of outsmarting each other in a whirlgig of technicalities to the detriment of the determination of the substantial issues between them, unquote, seem to be a distant memory. Our present reality is that appeals are now struck out of the Supreme Court after spending decades to work their way up there because a lawyer's seal was not affixed on the originating process at the court of first instance. Suggested ways forward. A lot of the above problems, for instance, excessive delays, inconsistent decisions, and technicalities over substance, are caused largely by the excessive workload faced by the courts. For instance, I have been told on several occasions that the Supreme Court of Nigeria is the most overworked Supreme Court in any country of the world. If that is true, this may be rectified by limiting drastically the right of appeal to the Supreme Court, whether as of right or with leave. Secondly, the attitude of our courts should change regarding the way leave is granted to appeal too readily. On the other side of the coin, I look back to the early years of my practice when judges were not overworked, and consequently cases were disposed of expeditiously and mostly on the merits. I remember that in the early 80s, I appeared before the Lagos Division of the Court of Appeal, then presided over by the late Justice B.O. Kazim. It was an application for a departure from the rules to allow my interlocutory appeal to be heard on the bundle of documents that I compiled that came up. To my surprise, when the case was called, Justice Kazim asked me if I was ready to argue the appeal. I reminded him that we were in court for my application for a departure from the rules. It was in February. Justice Kazim's response was that if I was not ready to take the appeal that day, he would adjourn my application to November. Of course, it was a simple appeal, so I said I was ready to argue the appeal that day. Counsel for the respondent also said he was ready. The application was stood down and heard later that day as an appeal. Of course, the court could do this because the workload was not unduly heavy for the justices. they had been able to digest the bundle of documents against the background of the notice of appeal and decide that the matter was a simple appeal that need not clog the docket of the court for much longer. It is high time the full complement of 22 justices provided by law comes to fruition, and this way, the Supreme Court will be able to have at least 3 panels sitting at the same time on a regular basis. It is within the discretion of the judges to award costs on an indemnity basis. Whilst most rules of court make provision for this, it is hardly ever the case. Courts routinely award paltry sums that have no bearing to the actual costs incurred by the party in whose favor they are awarded. Until costs are truly awarded on an indemnity basis, lawyers who feel that their clients have bad cases, particularly aspirants to the rank of SAN, will continue to have an incentive to maintain such cases or deploy all sorts of dilatory tactics to thwart the quick and efficient disposal of those cases or exploit their rights of appeal to the appellate courts. I have no doubt in my mind that the number of frivolous cases filed and maintained in court will be greatly reduced if lawyers and litigants were required to indemnify the winning party for their costs. This view is substantiated by examples from other advanced legal jurisdictions where costs are treated separately after the conduct of the proceedings in order to determine the adequate quantum depending on the peculiar fact and circumstances at hand. If indeed costs are compensatory, I wonder what compensation it is to award costs of 100,000 naira to a party whose lawyer has traveled from Lagos to Abuja on 5 occasions to have an appeal heard. In conclusion, it is my fervent hope that the judiciary, with the support and collaboration of the bar, will take the urgent action required to start the process of fixing our system of administration of justice. For where the citizens lose confidence in the judicial system, anarchy is assured. Also of significance is the fact that the effectiveness and the efficiency of the justice delivery system are major indices for attracting foreign direct investment, which are greatly needed at the moment in order to stimulate the Nigerian economy. Once again, I extend my hearty congratulations to all you new senior advocates of Nigeria. Also permit me to, on a personal note, congratulate one of you, a partner in my firm and mentee. As his senior partner and mentor, I have had a ringside seat to all the hurdles that he and by extension the other awardees had to jump to be here today. I confirm that it is no mean feat to attain the rank of Senior Advocate of Nigeria. I hope that you will all live up to all expectations. Once again, on behalf of BOSAN, I welcome all of you, newly sworn in Senior Advocates, to the inner bar, and hope that you will all play prominent roles in making our system of administration of justice fit for purpose. Thank you.
Thank you very much, the learned Senior Advocate of Nigeria. Next is the President of the Nigerian Bar Association, Honorable Yakubu Makeau, SAN, to give his address.
I thank your Lordship. My Lord, permit me with respect to adopt the protocol already established, but not without acknowledging my Lord, the Honorable, the Chief Justice of Nigeria, Honorable Justice Olukayode Ariwola, GCON. I am delighted and honored that the Honorable Chief Justice of Nigeria, Honorable Justice Olukayode Ariwola, GCON, extended an invitation to me as President of the Nigerian Bar Association to attend and deliver an address at this special court session to mark the commencement of the 2023-24 legal year of this court and the conferment on 58 of our colleagues with the prestigious rank of Senior Advocate of Nigeria. As part of my countdown, it would not be out of place to note that this would be the last legal year of this honorable court that I will be addressing as the president of the Nigerian Bar Association. I am grateful to God for the privilege, and may I express my profound gratitude on behalf of the NBA to my Lord, the CJN, and all the justices of this court for this invitation and for the audience I have so far enjoyed before this court. On behalf of the bar, my lords, I thank my Lord, the Honorable, the Chief Justice of Nigeria, for the honor of observing a moment of silence in honor of Professor Ben Nwabweze, Senior Advocate of Nigeria. May his gentle soul rest in perfect peace. The bar, my Lord, is grateful. The new legal year ceremony is a practice in many common law jurisdictions all over the world. It dates to medieval England, when judges in the New Year celebrations would adorn their ceremonial attire and take a 2-mile walk from the Temple Bar to Westminster Abbey for a special assembly to seek divine guidance and strength for the new year. This is a reminder to their lordships that judges and justices are representatives of God on earth, performing divine functions over fellow mortals. My Lord, earlier this year, I was privileged on an invitation by the President of the Law Society of England and Wales to attend the opening of the legal year ceremony of England and Wales on the 2nd of October 2023. My Lord, I must also take time at this point to pay tribute to those who designed our ceremonial robes. I had the privilege of attending that ceremony alongside a member of the member of the inner bar, who seeks, my Lord, all the time to threaten my height. And as we moved around, they walked up to us to admire our ceremonial attire, even those from England. And again, when one of our senior members saw the pictures, he called me and said, you mean you went to England? I said, yes, I went to attend the opening of the legal year ceremony. He said, like play. Aboki don't go London. I said, yes. And when Aboki went to London, he spoke English. The ceremony is also a time for stock taking, my lords. Today we listen to the Chief Justice of Nigeria appraise the bar, as well as the public, of the activities of the court in the previous legal year, the challenges, achievements, and the agenda for the new legal year. The bar is particularly interested in this because it provides the necessary enlightenment that will foster understanding in our interactions with the court in the coming year and beyond. This honorable court is undoubtedly one of the most overworked apex courts everywhere in the world. That is why your lordships are most deserving of the annual vacation of the court, the appreciation of Nigerians and the bar for the sacrifices which your lordships make in the discharge of the enormous responsibilities trusted on the shoulders of your lordships by the Constitution of the Federal Republic of Nigeria. I therefore, on behalf of the NBA, formally welcome your lordships from vacation. I'm not sure your lordships had any vacation anyway, as we usher your lordships with prayers to God Almighty for strength, wisdom, and courage into another legal year. On the second reason for this special court session, the investiture and swearing in of the 58 senior advocates of Nigeria, it has been the tradition to swear in the legal practitioners who are privileged to be conferred with the rank of Senior Advocate of Nigeria at the occasion of the commencement of the legal year of the court. Needless to say, the rank is conferred on legal practitioners who have distinguished themselves in the practice of law and have inter alia exhibited high regard for honesty and integrity and professionalism. I therefore congratulate each one of you for distinguishing yourselves and attaining this great feat in the profession. I must quickly admonish that to succeed in the use of this rank, in discharging the call of your office as a legal practitioner, a necessary trait upon which you must anchor all the requirements, all other requirements you had to satisfy to get to this height, is humility. It is humility that will continue to make the rank relevant, productive, and keep you within professional bounds. There is no doubt that you need the grace of God, and you need to remain humble for an infinite supply of that grace. The scripture that comes to mind is that which says, but he gives more grace, therefore. He says, God resists the proud, but gives grace to the humble. I therefore commend you to the grace of God Almighty, which is able to keep you humble and deliver you all the benefits that come with the rank of the Senior Advocate of Nigeria. I must also quickly add that from the speeches that have been delivered earlier before me, it is very clear that you have been sworn in as Senior Advocates of Nigeria at a time when the legal profession and the judiciary is challenged. The responsibility is ours to not only defend the legal profession, the integrity of the judiciary, and also preserve this country, because it is the legal profession that has the responsibility to continue to provide direction and do all that we need to do, which we must do in order to preserve this nation. And my Lord, today's occasion is being held at a time when the judiciary has been subject to relentless public accusation, discussion, publicly, possibly more than any other time in the history of Nigeria, where this scrutiny, constructive, there would hardly be any need, as it were, to dampen the mood of today's event with a critical examination of the state of our judiciary. My lords, the responsibility of the legal profession to educate the Nigerian public on the state of the law cannot be overemphasized. It is a duty that cannot be ignored or treated with levity, as to do so will be to the peril of the entire nation. By educating the public, we help shape the expectation of the public with regards to the justice that we all, as members of the legal profession, are called to serve either from the bench or bar to the people of Nigeria. And this responsibility or duty cannot be performed by any other person or profession. Only the bench and the bar can perform this sacred duty. Put differently, it is the sole responsibility of the members of the bench and the bar to dispense justice. And if justice is, and yes, it is, at the core of the existence or survival of our nation, Nigeria, then it necessarily follows that the survival of this nation rests and lies in our hands. This, in a nutshell, describes or depicts the enormity of the responsibility which has been trusted on us by reason of the privilege of our membership of the profession of law, and we cannot afford to shirk the responsibility, as the consequence of doing so would be grave. The resultant effect of the abdication of this sacred duty is chaos and anarchy. We can all very easily say or pray to God to forbid chaos and anarchy, but humble and submissive as that may sound, merely saying is an abdication. When God has given us all it takes to forbid a thing, it is abdication to look away from our God-given ability and call on Him, God Almighty, to step in to forbid what He has already given us the power to forbid. And we must act now and fast. It is therefore absolutely and uncompromisingly necessary that in the performance of our work as priests and ministers in the temple of justice, we remain focused and motivated by justice. Whenever we describe the lady symbol of justice as blind because of the blindfolding, she is only blind to extraneous factors and elements. The sentiments or prejudices which distract and detract from justice. all that the Lady Justices focuses on and sees is justice. And I should add that the eyes by which she focuses and sees justice are the inner eyes of the person of justice in members of the bench and the bar. This is the only way the light and illumination and transparency that comes with the presence of justice can be experienced by us who serve justice and those for whom justice is served. When the eyes of justice, administered by the bench and the bar, are focused, the entire polity, the nation, will be full of light, illumination, resulting in peace and development. This way, we achieve our role as socio-economic and political change agents of the society. My lords, there has never been a time in our history that judiciary came under attack like. My lords would agree with me that more than 90% of these attacks stem from election-related matters, which in so many ways have affected the other matters being handled by the courts. The question is, why do we have the preponderance of these accusations arise from electoral matters in cases dealing with politicians and political interests? Of course, this is not a recent phenomenon, for indeed, this court had, in the case of Buhari and INEC, Nikki Toby of blessed memory, observed thus. It is sad that so much has been said in the newspapers of this country on the case. The new technology of internet reporting has added to the comments, some of them doubting our integrity to do justice according to law. I regard them as blackmail. I will not succumb to blackmail. The way politics in this country is played frightens me every dawning day. It is a fight to finish affair. Nobody accepts defeat at the polls. The judges must be the final bus stop. And when they come to the judges and the judges in their professional minds give judgment, they call them all sorts of names. To the party who wins the case, the judiciary is the best place and real common hope of the common man. To the party who loses, the judiciary is bad. Even when a party loses a case because of a serious blunder of counsel, it is the judge who is blamed. Why? My lord, I repeat, even when a party loses a case because of a serious blunder of counsel, it is the judge who is blamed. And my Lord Honorable Justice Nikki Toby asked, why? The accusations and name-calling have, however, in recent times acquired a dimension that calls for grave concern and action. Whether we like it or not, it is these accusations, unfounded as they may be or can be, arising from these political matters that have largely shaped the public perception of the judiciary in Nigeria. Have we, members of the bench and the bar, who are privileged to be the ones to guide the public in regard to matters of justice, contributed in any way to fueling this negative public perception? There is no gainsaying that the duty to guide and provide direction to the people of Nigeria is the exclusive preserve of the legal profession. While this is a privilege, it also comes with responsibility. First, let me be clear. There is no ambiguity in the NBA position concerning the cacophony of unsalutary comments that have dominated much of the recent conversations about the judiciary over the last few months. We condemn these in absolute terms. I must particularly mention that it is regrettable that an unacceptable number of these armchair critics have come from the legal profession. The gale of unfounded allegations based on disjointed and jaundiced review of decided election petition matters by some of our colleagues cannot but be disconcerting. In all this, there is yet to be any specific evidence of impropriety. All that we have seen is general condemnation of the entire judiciary. My lords, talking about our responsibility to provide direction, I referred to the statement by Christopher Alexander Sapara Williams, who noted that the legal practitioner lives for the direction of his people and the advancement of the cause of his country. I also found very relevant the statement by Sir Adetokunbo Ademola, CJN of blessed memory, who said the respect in which the bar in any country is held is the best indicator of the freedom in that country. My lords, these are profound statements, and they are instructive and worthy of note and consideration in the discharge of our responsibilities. While the former speaks of all to all members of the legal profession, the latter is specifically addressed to the bar. We have a very critical role to play in society, and that is not something to be toyed with or taken lightly. The leading lights of the bar have largely remained silent when it comes to the education as it affects Nigerians. And this has greatly encouraged unprofessionalism amongst our colleagues. Silence has continued to thrive and has allowed all manner of information and misinformation to percolate through the consciousness of Nigerians, and have succeeded in molding twisted information, resulting in the attacks on the judiciary. Many unsavory and inflammatory remarks have been made and are still being made by members of the bar, denigrating and clearly inciting the public against the judiciary. Well laid down principles of law are twisted, tweaked, or taken out of context just to serve personal interests and not the cause of justice. These are made by persons who either deliberately misinform the public or do so out of sheer ignorance, not only of the law, but also of the facts on which the courts are called upon to apply the law. Neither of these two scenarios, my lords, is acceptable. Indeed, this is the point at which legal scholars, experts in the areas concerned, are expected to speak up through articles and journals to state the proper perspectives of the law, set the record straight, and provide guidance and direction to the public in line with our responsibility as legal practitioners to provide direction to the people. What is more pathetic is the internationalization of these views. These colleagues have decided that the solution to the challenges that we face at home is to tell the world that our judiciary and justice system are justice. They talk about corruption in the judiciary with so much authority. It defies belief that even as lawyers, they see no need for any evidence to back up their claims. At the recent conference of the International Bar Association, a former Attorney General of one of our states, gleefully and without a care in the world, told an international audience that the Judicial Service Commission in his state, of which he was a member, was immersed in corrupt practices. In very lucid terms, shared the story of how judicial appointments in his state were being sold for as much as 10 million naira, with lawyers and judicial officers in his state seeking judicial appointments. Quite apart from his tragic unawareness of his surroundings, he saw nothing wrong in being the chief law officer of a system that allegedly trafficked in judicial appointments, did nothing as the Attorney General, but only to travel to Paris to render a report of his tour of duty in that manner. I have written the said Senior Advocate of Nigeria, Mr. Uche Ehedua, Senior Advocate of Nigeria, a letter to supply me with the details of the persons allegedly involved in the racketeering of judicial appointments. I wrote a similar letter to Mr. Mison Nejo, the lawyer who said on national television that his client informed him that he had bribed the chief judge for a matter he was handling on behalf of the client to do likewise. I find it amusing that these colleagues appear to be pitifully oblivious that the same international community see them as products of the rot they gleefully proclaim. Allowing such misinformation or deliberate distractions to pervade the minds of Nigeria would only lead to uncivilized reactions to the justice delivery system, with the attendant consequence of refusal to accept the product of the resulting to chaos and anarchy. Those who engage in election petition proceedings in Nigeria form part of the creme de la creme of the legal profession in Nigeria. When we hear or read this statement, our colleagues, many of them of the inner bar, we owe Nigerians the bounden duty to put the record straight and be deliberate about disseminating the true position of the law in order to keep the expectation or reaction of the public within the bounds of law. We all know that cases are fought by the parties and adjudicated upon by the courts on the basis of what have parties. Talking about electoral matters, which is the focus here, it is the pleadings of the parties that circumscribe the limit of what the parties are allowed to do and the extent of what the courts are permitted to consider or look into. This is an elementary principle of law in every civil process. Lawyers, members of the public know this. Or maybe we should also ask, how many lawyers know this? My Lord, I refer to a case of this honorable court where the role of pleadings in the context of any civil proceedings was clearly stated. It's a tried position of the law, and that it is what you present, it is the pleadings that circumscribe what you can do as a party, and it is the court is also bound by the pleadings that has been presented. The court is not permitted to go outside of the case that was presented before it. It follows that what the court will do or can do in any given matter depends on what was presented before it by the lawyers. The court will not go outside of what was presented by the parties. If the preponderance of the leading voices of the bar will speak up to provide guidance, the public will be better informed. Public reaction will be civil. Confidence in the judiciary will be boosted, resulting in a stronger nation. This is my challenge to all my colleagues. And perhaps this brings us back to the pertinent question asked by my Lord Honorable Justice Nikki Toby in Buhari and INEC. When my Lord said, this is the case because of a serious blunder of counsel, it is the judge who is to blame. Could it be our professional work as members of the bar are not subject to make us liable to our clients for professional negligence in the handling of our matters, of their matters, such that it becomes convenient to point to the direction of judges and justices and alleged compromise as a cover-up for our blunder as counsel? I strongly recommend, my lords, with due respect, that the ongoing process of the amendment of the Legal Practitioners Act should consider subjecting the work of lawyers to scrutiny for the purpose of holding anyone who has not done his job professionally to account. We made an attempt in the remuneration order that was issued by the Attorney General to include the provision of an indemnity to clients, a professional indemnity, so that when you do any job, instead of looking away to cover up what we didn't do right, by pointing to the court, we would be held responsible. My Lord, the Chief Justice, permit me to now speak on what I consider to be the contribution of the bench to what has now become our experience. My lords, we all know that the ultimate judge of the universe is God Almighty, the creator of the universe, who is God all by himself, not created and does not depend on anyone or thing to be God. He is self-existent, is the self-existent one. The two attributes that flow from his throne are righteousness and justice. Your lordships, as you all know, but allow me to serve this as a reminder, are representatives of God on earth to dispense justice to the people who are made in the image and likeness of God, based on the laws we have accepted to guide and regulate our conduct as a nation. My lords, with respect, it is from this standpoint that your lordships are always called upon to dispense justice to the people in the discharge of your lordships' adjudicatory functions. It is in this wise that your lordships must not only serve justice, but must ensure that justice is seen to have been served. As a matter of fact, beyond these, your lordships are under an additional duty to persuade or convince the public for whom justice is served that indeed justice has been served in any given situation. This duty, my lords, cannot be discharged by either the executive or the legislature. It is the exclusive preserve of the judiciary. It remains true that at a time when public confidence in the executive and legislature has waned, the only hope is to resort to the judiciary. And where public confidence in the judiciary is completely eroded, the only thing the executive and legislature can do through the people is to take over your lordships, is not to take over your lordships function, but would be to reform the judiciary to keep or regain that confidence. The point I'm making here is that the job of dispensing justice is that of the judiciary, and only the judiciary can do it. Otherwise, the only other option would be for Nigerians to resort to self-help with chaos and anarchy. But like I said earlier, we can forbid that. Therefore, for your lordships to perform this all-important function, the system has provided a set of rules, regulations, and code of ethics for judicial officers. The observance of these rules and judicial code of conduct are meant to keep the product of what is served by with the active but professional and ethical participation of the bar acceptable as justice, with the additional responsibility of ensuring that the public always perceives the bar, the bench, and the bar as being justice-minded and people-oriented. That is to say, a legal profession primarily motivated by the desire to do justice, no more, no less. With the fast decline of the public confidence in the judiciary, while the several allegations of compromise against the judiciary remain baseless, unfounded, and unproven, there is the urgent need for the judiciary to sit back, introspect, recalibrate, and relaunch itself in the opinion of Nigerians with a renewed focus that will change the negative narrative to elicit and command the confidence of the public. Judicial officers must take their oath and judicial code of conduct seriously, must avoid actions and omissions that will give the appearance of compromise. Like Caesar's wife, judicial officers must be above suspicion, above reproach. Proven cases of judicial misconduct must be dealt with decisively. And here I thank my Lord, the Honorable, the Chief Justice of Nigeria, for what I consider the riot act that my Lord read out this morning. In a lecture titled Dissenting Judgments and Judicial Law Making, in honor of Honorable Justice Adolphus Godwin Karibi White of blessed memory at the Nigerian Institute of Advanced Legal Studies, my Lord Honorable Justice Oguntade, Justice of the Supreme Court, retired, had this to say: a judicial system thrives when, by its judgment, it instills confidence in the larger society that it is fair, impartial, and corruption-free in the adjudicatory process. A judiciary that is weak, corrupt, and unreflective of the people's aspiration is irrelevant to the people and doomed to collapse with time. All these, I must say, can only be achieved where there is synergy between the bench and the bar. Acts of professional misconduct by members of the bar must be condemned and punished. The bar will also pursue cases of judicial misconduct and ensure that they are dealt with appropriately by relevant agencies and authorities. This must be our common goal. The bench and the bar must collaborate in the fight to salvage the nation. We expect the bench to expose any clear case of professional misconduct by members of the bar, while on the other hand, the bar must ensure that all efforts are made to expose provable allegations of judicial corruption. Those members of the bar who claim justices collect bribes should quit being cowards and make bold to present the evidence to law enforcement agencies, even when the bribes are allegedly given by or through them. It is a sacrifice that we must make to save the nation. I recall in a book I read where a lawyer had to go and give up his client because I think it was in Chicago, one of these drug barons. They couldn't find any evidence against him, and the lawyer was fed up. Each time they went to court, he went scot-free. He was the one that provided the evidence. We can be bold enough to do that. Otherwise, going around to accuse judges and justices of corruption without any evidence. It's even worse than the corruption itself. Let us be bold to come out and do that. I therefore call, my Lord, on the judge who alleged that the senior counsel attempted to bribe the tribunal in Kano to also furnish us with the evidence of that senior member of the bar that attempted to do that. And my Lord, if this cannot be done, because the allegation that was made was unfounded, the bar with respect demands an apology, just as I have severally done for the unwarranted hurt caused to your lordships by members of the bar. I must in this wise commend the Court of Appeal by Honorable Justice Ugo Moses and Bolaji Yusuf, Justices of the Court of Appeal, in the bold step of calling out on condemning the actions of members of the bar who derided and treated the courts derogatorily. And my Lord, I'm making reference to the Presidential Election Petition Court, when the Court of Appeal sat as that court. With due respect to this honorable court, the failure of your lordships to invoke the court's coercive powers, despite the discourteous and irreverent manner in which some members of the bar treated the court in the wake of the presidential appeal proceedings before the court, the threats, outright abuses, and derogatory remarks after the proceedings did not help in sending the right signal to the public and worsened the perception of the public about the court and the judiciary at large. That the court did nothing, my Lord, did not punish any of those who clearly went on a spree to denigrate the courts and the institution of the judiciary, made the public think that what was said of the court were true. Much as some of us in the bar do appreciate the basis of your lordship's silence over such despicable and unprofessional conduct, which was consistent with your lordship's code of conduct as judicial officers, it was, in my opinion, counterproductive. At the minimum, your lordships would have handed down some hard strictures that would automatically have served as a basis for disciplinary proceedings against the erring members of the bar. Until such examples are made, many would continue to lend their licenses to practice law as a tool to serve the whims and caprices of their clients at the detriment of the profession and the country at large. While we know that this honorable court recognizes the fundamental rights of citizens to free speech and access to justice, these rights must be exercised within the ambit of the law. They are not open-ended rights that are exercised recklessly and irresponsibly. My lords, in an article published in the Washington University Law Review in January 1955, a former Chief Justice of the United States District of Columbia, Bolita L.J. Laws, observed, "We have read news and magazine articles criticizing the courts. We have looked at many motion pictures which have depicted silly and sometimes dishonest court proceedings. Some criticisms have been justified, but many have not. Courts have suffered bitter censure for unpopular positions they have been compelled to take, positions which were absolutely sound in law and were necessary for the welfare of individual and nation. When judges have been subjected to the sting of false and misleading statements, it is shocking to them as individuals. This in itself may not be so important, but it is important in the extreme when the prestige of their courts is hurt. Let me be clear. We have no fault with just criticisms. Citizens have the right to criticize. Indeed, one object of bringing citizens to confer with lawyers and judges is to get constructive criticisms. But we like criticisms to be just and to be based on facts. In the preface to the book, Judicial Activism in India, my Lord, the Nalayan author of that book, talking about the role of the Supreme Court in India, said this: "An analysis of the judicial behavior of the Supreme Court in the last 2 decades clearly shows that public adulation has not swayed the judges much, and personal aggrandizement has been eschewed successfully, barring a few stray incidents." And my lords have demonstrated that strength of character when your lordships would not allow Executive Order 10, even when it was meant to serve the interest of the court. Your lordship stood your grounds to say that the act of the president was unconstitutional, and your lordships will not endorse what is not constitutional. My lord, he continued, the judicial activism is no activism if it is not accompanied by judicial accountability. As Justice Robert Jackson of the United States Supreme Court said, we are not final because we are infallible only because we are final. The Supreme Court continues to be supreme but not infallible. Another development that needs to be mentioned in this context is the exercise of contempt power by the judiciary in recent times. There have been a few occasions when the judiciary appeared to have become a little oversensitive to constructive criticisms. In the words of Justice Krishna Iyer, free speech is a fundamental right, so too free access to justice. To strangle both these freedoms because the courts are allergic to what they regard as savage criticisms is to foster judicial tyranny and tantrum. But my lord, the author added, at the same time, it is always better to remember that where the contemner is a foolhardy bully or literary terrorist against the judiciary, heavy corrective sword should be unsheathed. I commend this approach to your lordships for the many judicial bullies and literally terrorists in this country. This honorable court must, in the overall interest of the country, unsheath its heavy corrective sword accompanied with judicial accountability. Although I have severally made the point clear, I will say it again for avoidance of doubt. I am by no means condemning in totality the criticism of judgments of court. However, as I have always said, such criticisms must be constructive, done through well-researched articles, academic papers, books, scholarly debates, and panel discussions, not personal insults and attacks on the judicial officers. On this point, my lord, I will refer to a book written by one of us, the senior advocate of Nigeria, Chief Charles Mekunye, Constitutional Law in Nigeria through the judgments of the Supreme Court, where he dissected some of the dissenting decisions of this honorable court and how judgments were delivered on the basis of what was presented by the parties. My lord, I now turn my attention to other challenges facing the judiciary and the justice sector, even without the gale of election petitions that appear to have, in many ways, taken over our justice system. There is something fundamentally wrong with the justice system that shuts down at the end of every electoral cycle. It is a paradox of some sort that the judiciary is at the receiving end of problems that it did not create. The judiciary neither enacted the laws that govern the electoral system nor appointed persons saddled with the management of the process. It is certainly not the judiciary that removed the spirit of conceding defeat from our politicians, even those politicians who by any stretch of imagination and under any circumstances cannot win community association elections have resorted to challenging presidential elections in our courts. Our colleagues who are now deeply emotionally tied to the politics of the moment should know that this season of anomie will pass, and what will remain forever is the legal profession and the justice system in which we eke a living. My lord, talking about eking a living from the legal profession is even a selfish concern. What is fundamentally important is the fact that this attitude and conduct, if not curbed, would only result in the collapse of our nation, and we cannot afford to let that happen. I share the concern of many of my colleagues about our collective inability to make rapid progress on the judicial reform. Every aspect of our justice system and institution requires rethinking in significant ways if we are to achieve our desire of a justice system that works in the interest of all Nigerians. I hear those who want to know what the NBA is doing. The record of achievements of the Nigerian Bar Association during its more than 90 years of existence emphasizes that it is a dynamic force in improving Nigeria's justice sector, including the maintenance and defense of the integrity and independence of the judiciary. However, it is important to note that the NBA has no compulsive power either over individual lawyers or government agencies. We have no legislative or executive or judicial power. We have no patronage to dispense, no palliatives to distribute. Our powers are solely those of deliberation. We succeed so far, and only so far as we are able to appeal to reason and conscience of decision makers. We are leading from the front. The judiciary and indeed the justice sector is indispensable to the sustainability of our judiciary. In fact, despite all the hullabaloo, the indispensability of the judiciary has been affirmed. That is, what is now beyond doubt is that the current constitutional framework that governs our judiciary is not sustainable. There is an urgent need for a radical review of all aspects of adjudication, from the appointment of judicial officers to matters of case management, including limiting matters that should be heard by the Supreme Court. It is for these reasons that the Nigerian Bar Association Judiciary Committee, led by Babatunde Ajibade, Senior Advocate of Nigeria, has over the past couple of months undertaken inclusive consultative process aimed at putting forward a comprehensive MBA position on judicial reforms. We shall shortly be presenting our position to the National Assembly as part of the ongoing constitutional review process. We are also concerned about the condition of service of judicial officers. My Lord, talking about case management, one of the senior advocates to be conferred today, Isaiah Bozimo, was in his mommy's tummy when his father argued an appeal, and he ended up arguing a case at the trial, arguing the appeal at the Supreme Court himself, the child who was in the tummy of his mother. The same senior advocate that my elder brother here referred to earlier. Our concern is by no means limited to the issue of remuneration. The entire gamut of the working environment of all judicial officers, particularly those in the lower court, requires urgent review. We have focused on judicial remuneration as part of our contribution to the ongoing review of public officer remuneration by the Revenue Mobilization and Allocation and Fiscal Commission. The NBA Working Group on Judicial Remuneration, Conditions of Service, chaired by myself and co-chaired by Olawale Fapuonda, put together an advocacy briefing note for the consideration of the Presidency and National Assembly. In very specific terms, my lords, it simply cannot be right for our judicial officers to be on the same salary and allowances structure for more of almost 2 decades. I must not fail to note that though some Nigerians have brazenly come out to desecrate the judiciary and label the institution all kinds of derogatory names, the fact remains that most Nigerians still look to the judiciary as the final resort to protect their rights and secure probity in public life. Like I said earlier, it is only the judiciary that can discharge this sacred duty, and we must get it right. Only recently, this honorable court, in what was described as a people-oriented decision, salvaged this country from the brink of economic collapse through the decision in the case AG Kaduna State and others, and the AG Federation, the Naira redesign. Even though those foolhardy bullies and literary terrorists against the judiciary did not relent in their reckless attacks on the court, they now carry Naira in their pockets, do transactions for themselves and their families, but have refused to acknowledge the rich intervention by this court, which they greatly enjoy. Notwithstanding such attitude, my lords, your lordships are encouraged to continue to discharge your constitutional duties without fear or favor, affection or ill will, and remain judicially accountable to the larger number of Nigerians who still see and recognize the judiciary as the place of final resort for the protection and enforcement of their rights. My lord, another important arm in the struggle for judicial independence is the JUSUN, the Judiciary Staff Union of Nigeria. I want to use this opportunity to commend the leadership of JUSUN because of the camaraderie they've expressed towards the Nigerian Bar Association. We've had meetings with the Attorney General and the leadership of JUSUN, and that way we ensured that they did not join in all the strikes and even the notices that they gave that they were going to go on strike because of the non-implementation of all the judgments that they secured relating to judicial independence. They withdrew from that strike. My lord, I must commend them. We recognize the fact that without them, the courts will not be functional. In conclusion, my lord, I wish your lordships God's strength and the wisdom to carry out the assignments set before your lordships. I wish the court a fruitful year ahead, and on behalf of the Nigerian Bar Association, I reiterate our commitment to maintain a robust bench and bar relationship from the understanding that we are both agents of the same principal, justice, performing different functions to serve the cause of justice. The bar continue to defend the integrity and independence of the judiciary, and in the same vein, hold the judiciary alongside other arms of government accountable to the people of Nigeria. Once again, my Lord, congratulate my new brother and welcome. Finally, I thank your lordships for this occasion. I thank everyone present for listening. I thank your lordships.
Thank you very much, the Honorable Nigerian Bar Association, Honorable Yakubu Makeao, SAN. Now to the representative of the new silk, Felix Ota Ofia, SAN. Over to you.
My Lord, the Chief Justice of Nigeria, the Right Honorable Olukoyede Ariola, JSC, GCON, my Lords, Justices of the Supreme Court of Nigeria, my Lord, the President of the Court of Appeal, and other justices of the Court of Appeal, the Honorable Attorney General of the Federation and Minister of Justice, judges of the High Courts, and the National Industrial Court, the President of the Nigerian Bar Association, Mr. Yakubu Makeao, OON, SAN, Leonard Silks, Leonard members of the bar, distinguished ladies and gentlemen, all other protocols observed.
Yes, Mr. Ofia, SAN.
Yes. Yes. I'm so sorry. Well, I just mixed up the papers. Well, at this August gathering of eminent jurists and personalities who have graciously come here to witness this somber occasion, we are humbled to be the center of such eminent attention, even for a few hours, and for which we give thanks to the Almighty God, who superintends all human affairs. We, the new silks, we have individual reasons to thank my Lord, the Chief Justice of Nigeria, Honorable Justice Olukayode Ariwola, JSC, GCON, as the chairman of the Legal Practitioners Privileges Committee, charged with the selection and conferment of the rank of senior advocates of Nigeria. History will record that despite the thorough and rigorous exercise. For the first time, all applicants who scaled the first and second refiltrations, including the chamber's inspection exercise, they met the rank. That will speak to my Lord's immanent sense of firmness and fairness. And so we do hereby collectively salute my Lord for his firmness and fairness. Let me seize the opportunity of this rare occasion to canvass some topics relating to the rule of law. With the kind indulgence of my Lord and with the kind permission of my colleagues for whom I stand here. The idea of the rule of law is usually ascribed to Albert Dicey, who expounded the concept of the rule of law on the following three principles in his book, An Introduction to the Study of the Law of the Constitution, published in 1885. Those three principles, I think we all know, are one, the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary law, power. Two, equality before the law, or the equal subjugation of all classes to the ordinary law of the land administered by ordinary courts. And three, the law of the Constitution as a consequence of the rights of individuals as defined and enforced by the courts. Now, everywhere we turn to, there are rules, even among animals, whose own various pecking orders adopt the rule of brute force only. Humans, whether at play or at war, they have rules. Society is inconceivable without rules of law. We accept or obey law in exchange for order in the society. It is by now universally acknowledged, especially in democratic jurisdiction, that the rule of law is the linchpin for the delivery of all policies, to the extent that the rule of law has become a cliché talking point. If we must achieve the level of production quantifiable enough to sustain the welfare and happiness of our citizens, which is a primary concern of governance, then we must sustain the rule of law. One important pillar of privatization, a rung on the ladder of production, is the liberalization of profit based on reward of merit. The other is the rule of law to enforce it. For there can be no justice without prompt law enforcement. It is the rule of law that anchors the ship of state in the face of fierce political storm. The adherence to the rule of law is what separates us from the wicked forces of chaos. And in governance, the governor should always play the politics and the economy in symphony to produce a harmonical social note. I'm here, however, for now, concerned with one link in the great chain that is the rule of law, namely legislative draftsmanship. There appears to me to be a serious dearth of experienced legislative draftsmen, particularly in the executive arm, as a large majority of our bills originate from the executive. This lack arose from years of neglect of the department during the years of the military rule, when legitimacy of governance flowed not from the electorate, but from the barrel of the gun. And military rulers, caring less for the niceties of the rule of law, churned out decrees and statutory instruments from their desk drawers. The legislative draftsman thus fell into oblivion and utter disuse. On the resumption of constitutional democracy in 1999, there were a few legal draftsmen who survived the long period of neglect and frustration. I'm not just referring to a convenient or punitive departmental posting of a legal officer not specifically schooled in legislative draftsmanship. And by legislative draftsmanship, I mean that obscure legal officer with little or no contact with the public in the execution of his official duties. Having years of training and experience, well steeped in the nuances and intricacies of those deep and backbreaking researches needed to avoid conflicts with poor legislations. And preceding the drafting of a bill intended for presentation to the National Assembly for passage into law as truly an act of the duly elected representatives of the people. There appears to be a dearth of experienced legislative draftsmen, and this, in my opinion, is endangering the quality of legislations for the interpretation by the courts. Legislation should be clear and unambiguous in order to express its objective. Our principal source of law is legislation enacted by the National Assembly, seeking to introduce new rules or to amend new ones in the name of reform, progress, or the much vaunted improvement of our lives. Sometimes, because a body like the National Assembly can have no mind, it is not possible to consolidate individual intentions into a collective fictitious group intention. So, the provisions of a statute need to be understood in the context of the purpose of the statute as a whole. And this requires first an understanding of the context in which it was enacted and the mischief at which it was aimed. It is the responsibility of the legislative draftsman to aid the judicial approach to statutory interpretations. I am aware that there have been well laid out principles in several judicial authorities on statutory interpretations by this honorable court. On the various rules, namely the literal rule, the golden or purposive rule, the mischief rule, etc. The draftman should lay or lays down the rail track for the coach of interpretational movement to glide on the voyage of discovering the intention of the assembly, whether national, state, or local. It takes years of training and experience to perform this function. For instance, in Temple Nwankwala versus Federal Republic of Nigeria, 2018, where the issue was whether the Corrupt Practices and Other Related Offences Act 2000 or the Corrupt Practices and Other Related Offences Act 2003 is a valid law. The case illustrates the likely damage to the rule of law in cases of poor or inelegant legislative draftsmanship, because the two statutes, in quote, just stood for validity before this honorable court and needlessly. Let's very briefly examine the living conditions of two conditions.
Thank you very much,
of Evidence Act. My Lord.
I thought you were concluding.
No, sir, just a minute.
Okay, thank you.
Just a minute. Let us examine two legislations and see the quality of draftsmanship.
Keep those two legislations and move forward, because we have been seated for almost 3 hours.
Okay, sir.
Please, thank you very much.
Okay, sir. Do I go on?
Go to conclusion, please.
Okay. Yes, sir. Yes, sir. There is none. Yes, sir. Now, let me conclude. Let me conclude by saying that the call here, my Lord, is for an investment in the training of legal draftsmen.
Yeah.
And supporting them, bringing them their confidence back, so that they can draft laws expertly, which will help the courts to interpret and help the rule of law.
Thank you very much.
Therefore, we thank you. I just want to thank the members of the Legal Practitioners Privileges Committee.
Thank you.
Who strain themselves at each stage of the exercise that brought us here today.
Thank you very much.
Traveling long distances,
yes,
and enduring long hours of inconvenience to make the outcome. We salute our judges who daily, thanklessly, but doggedly, they assist the blindfolded old lady of justice, holding up the inimitable scale of justice. On our own part here, we promise not to allow the applause of this moment to drown the essence of the duty now hosted on us by the conferment, the task of keeping the flame lit by those who have trod this path before us on the path we are about to embark. And we promise to keep the flame lit and burning. Thank you, my Lord.
Thank you very much, Mr. Felix Ofia, SAN.
Yes.
My Lord,
thank you.
My Lord, the former Chief Justices of Nigeria, my other brother lords of the Supreme Court serving and retired, my lords of the Court of Appeal, all heads of court, non-as senior advocates, Your Excellencies, Your Royal Highnesses, my Lord Reverend Kuka, members of the Inner and Outer Bar, President of the NBA, other Royal Highnesses, distinguished ladies and gentlemen, we appreciate you for your time, for your patience and understanding. We thank you very much and look forward to see you again. Shortly, the court will rise, and after other announcement by the Chief Registrar, the court will rise.
I have the permission of the Honorable, the Chief Justice of Nigeria, to announce that refreshment will be served at the Justice's entrance foyer for invited guests only, please. The court will rise.